I'd like to introduce myself. I'm Leanne Levenstein, CEO of EconoServe, and I'd also like to just welcome all of you here today for the launch of our Labour Law Managed Service. Thank you. So a little bit of background to our journey so far. EconoServe was founded in 2005. We were, back in 2005, a specialist BEE consultancy. So we started out looking at BEE. As a lot of you might know, or some of you might know, the first legislation was gazetted in 2007. So we actually got involved quite a lot sooner than that. And we got ourselves up to speed pretty quickly. We developed some systems and tools to help our clients earn points on the scorecard, maximize their points on the scorecard in as best a way as possible. So we became very well known in the BEE industry. We've enjoyed the work that we've done over there for the last 11 years already. So being the veterans in the industry of BEE has taught us quite a lot of things, probably not the most important, but one of which is that with legislation, there is always differing interpretation. There is always a lot of different ways to see things. There's a line. We don't always like to cross that line. In fact, we never cross that line, but we always look at things in as objective way as possible. And today is a special day for us because we are launching our Labour Law Managed Service. Again, we've seen a huge need in the industry and with companies to add on services to add on services that we have to fulfill their particular needs. And today we are very proud to announce that we are launching our Labour Law Managed Service. We have also got a partnership with Dr. Alec Wainwright, who's sitting down next to me. He has more qualifications than I can even name, so I'll read them quickly. Doctorates, masters, honors, bachelors, and a 3-year tertiary qualification. So there's a lot of, I suppose, when you were studying, there was no protests or anything like that. Not what's going on at the moment. He's been a successful labour law expert. I won't give away your age, but for a very, very long time. Okay, so I won't do it, so you can. He's a former CCMA commissioner, which I think is actually, it gives so much experience and so much insight. He's presented papers at international conferences, and he has served on a commission of inquiry into industrial unrest. So he is absolutely perfectly poised to do the presentation for us this morning, and an absolutely excellent partner to us on the Labour Law Managed Service side. So without further ado, I'll hand over to you.
Let me give you an example of the questions that the commissioners will either ask you. If they don't ask you, they are internally asking themselves whether you have fulfilled this. So for procedural correctness, this is the checklist that's handed to commissioners as part of their training. For procedural fairness, this is what they're looking at. Was a notice of a hearing given? So you've got to go and the person a written notice. Was the notice given in a language that the employee can reasonably understand? Did the notice alert the employee to charges that he would have to answer to? Were the disciplinary proceedings commenced properly and without delay? Was the employee given a reasonable time to prepare for the hearing? Was the employee allowed to be represented? Was the employee in fact represented? I want to stop you right there. If you're holding a disciplinary inquiry and a person says, no, I don't want a representative, insist on a representative. The next question that the CCMA will be looking at is the employee a union official or shop steward? Why would they ask that question? Does anyone know? Why would they be very interested to know if the guy's a shop steward?
It can be represented by a union official.
Correct. What is the act? Okay, you're right. The act actually says that before any discipline is enacted against a trade union, you've got to consult. You've got to consult the union. So the union's trick is this. They will arrive for the disciplinary inquiry, and they will say, okay, now you've consulted me, but I'm only available for the continuation of this inquiry in 3 weeks' time, which means that that thief then gets an extra 3 weeks' wages. So the way to obviate that is to say to the union, in terms of section so-and-so, clause so-and-so of Schedule 8, we wish to consult with you at 9 o'clock. At 10 o'clock, we are commencing with a disciplinary inquiry. And you can put it forcefully. The consultation is not a negotiation. We're consulting you, but we are still going to go ahead with disciplinary action. Now, concerning procedural correctness, the next question that the CCMA Commissioner will ask you, either openly or try to establish from the minutes or the proceedings, is, was the employee allowed to listen to all the evidence of the respondent's witnesses? Was the employee allowed to cross-examine or challenge the respondent's witnesses? Was the employee allowed to give evidence in his own defense? Was the employee allowed to call witnesses in support of his case? Did the employee request an interpreter? Was that request acceded to? Was the chairperson impartial and unbiased? Was the employee allowed to leave evidence in mitigation of sanction? Yes, this is what you have to do. You have to remember this. Once you find the employee guilty, you must adjourn it, even if it's for 5 minutes, to go and have a cup of tea. And then you're going to say, well, during this time, I'm going to consider the evidence. Even though the evidence is staring you in the face, you still must do this because it shows that you're applying your mind. These are the little games you have to play to win. And then you say, I do find you guilty for the following reason. Now, before I hand down the sanction, because that's the verdict, the sanction is first warning, second warning, final warning, dismissal. Can you tell me what plea you have in mitigation? And then you must explain the concept, what it means, because the person's going to say, I didn't understand it. And you say a plea in mitigation is, for example, a thief is before a magistrate, and his lawyer says to the magistrate, this man didn't steal a Rolex, he stole food. He's unemployed and his wife's unemployed. That's a mitigating factor. Was the employee informed of the outcome in writing? Because clause 4.3 of Schedule 8 says that if an employee is dismissed, he should be given the reason for the dismissal, obviously in writing, and informed of his right to take the matter to the CCMA or to the bargaining council within 30 days. So you actually have to say to him, you have the right to take me to the CCMA, and you must put that in writing. Was the employee informed of his right to appeal? Did the employee appeal? What is the date of the outcome of the appeal? Etc., etc. Now compare all of those procedural aspects that the CCMA is looking at, and yet the Act says this need not be a formal inquiry. And I will make another example of this. And this example cost my client over R1 million. It wasn't my fees. It was a case that went on for 4 years. I can't mention the company's name, but I can mention every detail relating to this, because it's not a breach of client confidentiality. This client works with heavy machinery, okay? And there are signs all over the place saying, zero tolerance to alcohol and drugs. And they've got an apartheid-era dog handler policeman who is thick as a plank, and he, in his officious manner, decided to be far too clever. A guy came in who tested positive for DACA. So this ex-cop, being very clever, said, in terms of the Occupational Health and Safety Act, clause 5.3 of so-and-so and this and that, you are under the influence of DACA. Okay, that was the charge. I'm coming back to that because that charge is absolutely vital, the nature of the charge. He made a second mistake. He sent the guy home. He said to the guy, I will test you in a month's time. Exactly 31 days later, the guy came back And he had been warned he's going to be tested again for Dachau, and he again tested positive. Now that's another mistake that the company made. Why? Now, this is a very cynical comment. If you are drunk once, or if you're under the influence of Dachau once, it's misconduct. But if you are drunk many times, it's not misconduct. It's an ailment, it's a sickness, it's a dependency problem. So if you're many times guilty, now you're sick. I'm being very cynical, but I think you're taking my point. So he came back 31 days later, he tested positive again, and NUMSO said, definitely, this guy should have been sent for rehabilitation, etc., etc. The company won the arbitration. It went to the Labour Court. This is 4 years later. My daughter's a labour law advocate, and I referred the case to her, and the acting judge took up this COPS charge sheet, which was, the person was under the influence of Dachau, under the influence. And the acting judge said, but you can't prove that the man was under the influence. And the judge's point was that if you have one beer and you're stopped by the cops, you can test positive, but you're not under the influence. So that point is slightly valid. But what we try to argue, but the judge would have none of it, is how are we expected to establish if he's under the influence? Because in terms of the law, if a person's at a factory and he tests positive for drugs, you're not allowed to let him in 1 yard further. You can't say, well, come in and work with this machinery, and if you kill somebody or if you injure yourself, then we will establish whether you're under the influence. So, 4 years later, and R1 million in legal fees, guess what the judge said? Instead of bringing finality to this thing, he said, I'm sending it back to the Metal and Engineering Industries Bargaining Council to be reheard by another commissioner. At this point, the company was exhausted. At this point, the union was exhausted. And the union never ever proceeded with it. They just gave up, because they would have had to have started all over again. The point that I'm making is, this need not be a formal inquiry, very formal. Make it very formal and be very aware of the charges that you're going to cite. If someone steals something from the factory and walks past security outside, and you've got him with the spanners and the hammers and the things that he's swiped, what charge are you going to cite in that notification? Any ideas? What would you write in his notification?
Unauthorized removal.
Thank you. Unauthorized possession or unauthorized removal of company goods. Because it's far easier to prove that that guy outside the premises had not got permission from the company if he could borrow those instruments, go and work over the weekend. Because if you charge him with theft, you're going to have to show that his intention was to steal it. And he might just say, as he's obviously had some experience of these things, he might just say, well, I wanted to borrow them for the evening because I had to do some electrical work or something in my house, but I had every intention. Now, if you've got incorrect procedures at the CCMA, you're going to get hammered on them. So you've got to have proper procedures in place, and it's obligatory that you follow your own unilaterally implemented procedures. You cannot have procedures that you take shortcuts with. If your procedure says, do this, you must do it. Thank you very much. Oh, no, wait, you've got to talk.
Mine was a thank you to you, so I'll just say it on the microphone. A big thank you to Dr. Alec Wainwright for doing the presentation this morning.